the dubious honor of being the last person today. The good thing is these lights are so bright that I can't see that there's a bunch of empty chairs. Can I just have a show of hands? Are there any IP attorneys, intellectual property attorneys in the audience? One, good. I was late getting here, and the reason I was late getting here is because I was giving a talk to a room full of intellectual property attorneys. So this is a much friendlier room, believe me. Okay, so we're going to get the slides up in a second. Oh, is that them already? Clicker is on the podium. Over here, perfect. So my name is Crystal Shepard. I'm director of the Midwest Regional Office for the United States Patent and Trademark Office. Most of you here are in innovation. The problem with innovation, I shouldn't say that, people always talk about innovation and how great it is for the economy. However, innovation in itself means nothing. You won't hear anyone else say that here. Why do I say innovation in itself means nothing? If it costs a drug company $1 billion to invest before they can get a drug released, before they can release a drug, are they going to put that $1 billion in there? Are they going to innovate if they have no way of recouping their funds? Same with what you all are doing. And in the world of connectivity, in the world of disruption, how do you stop the person from right next door to you from doing something exactly the same as you're doing, but recouping the benefits without all the hardship? The way that the government deals with this is intellectual property. And whenever I come to conferences like this, the room is always mostly empty. And the thing is, the people who know that they should be in here, or that they are in here, it's the rest of the people who don't know enough to know that they should be in here. That usually is our market. So I'm going to use you all to go out and tell them. So just quickly, that's who I am. We have a regional office. The United States Patent and Trademark Office has been open for 226 years. The intellectual property is so important to this country that it is in the Constitution. There are very few things in the Constitution that are told to Congress that you can do. This is one of them because it's so important to our economy and has been for so long. For 222 of those 226 years, the only place you could go and talk to an examiner was in Washington, D.C. The only place you could go and talk to upper management about patents and trademarks and copyrights was in Washington, D.C., in the nation's capital. 4 years ago, we opened the first office outside of Washington, D.C. Why? We wanted to get to people like you. Many of you may work for companies that are able to have lobbyists or lawyers who go to the nation's capital, but a lot of you don't. So having the regional offices gives you an avenue to have as big a voice and as big a chance as getting everything you need to know about IP as the big guys. So IP is not just about suing people. It is a business strategy. So if you have a business plan without a mechanism of recouping your investment in your innovation, I would say that's probably not the best business plan on the planet. There are other reasons to have patents or trademarks and that sort of thing. It's not just about suing someone. It's attracted to inventors and buyers, defers infringement lawsuits. It can increase leveraging power. It can increase your property's assets. But even so, the problem here is most people don't know the difference between a patent, a trademark, a copyright, a trade secret, trade dress, or design patents. And I'm not here from the patent office to sell you on writing a patent. Not everyone needs a patent. In fact, most of you probably don't. But everyone in this room, someone claps, yes. But most of you in this room, if you have a product, if you have a company, it must have a name. And if it has a name, trademark is implicated. I talked to someone yesterday or 2 days ago when the director of commerce was here, Penny Pritzker, and a small startup, no, a bigger startup, you've probably heard of them, so I won't tell you who they are, who ran into a trademark problem with their name. Now they're well known, they've been doing it for a while. And they've been doing it for a while and are well known However, they never did a trademark search before they decided to use that name. Now, 2 years down the road, there's someone saying you have to stop using that name. What are they to do? So since you're not patent, trademark, copyright, trade secret, or trade dress fluent, I thought I might go through that for a second. Before I do that, I kind of want to talk to you a little bit about your industry and about disruption. I teach a class, or I'm also a law professor, I teach a class on how the law reacts to innovations in science and technology. If we go back to the 1400s, which we're not going to do for more than a minute, 1400s, the way that the law reacted to innovations was to provide protections to citizens, to allow them to recoup money from their inventions. In Venice, they said, okay, we're going to give people from outside of this country protections for their inventions in Venice. If you have protection for your inventions in Venice, but you don't have them in, let's say, London, where are you going to practice your invention? Venice. So that was a way that Venice started coming up as one of the places that had there was an intellectual capital of the world at the time. They really benefited from that. Venetian glass benefited from the protections that were available. And it was available because of the disruptions of technology, the new technology for glass. So we're going to jump ahead about 400, 500 years to the time when we went from horse and buggy to cars. And I would say, does anyone here remember that? From horse and buggies to cars. Is that much different from what you're going through right now? Going from cars to autonomous vehicles? Going from self-driving, so going from driving yourself to self-driving? There are people who are on the other side of these issues. They have a legitimate business reasons to be on the other side. In the case of the horse and buggies versus the newfangled cars, you may have heard of what's called the red flag laws, where in England, the other sides came together to say, we need to protect our industries. How do we do that? Legislation came through that required a person to walk in front of the cars with a red flag to let people know, horses, walkers, everyone know that this horrible vehicle that could hurt people was coming down the road. It required the hobbyists, who at the time the people who were having the disruptive industry, to band together to go against them. And I will tell you that the industries that you're all in, the disruptive industries, are usually less organized than those that are more organized. And I see that every day. And part of the organization is being sophisticated in how you are going to not just innovate, but how you're going to protect. So, patents, trademarks, copyrights, trade secrets. Raise your hand if you know the difference between these two. If you raise your hand between them, I won't ask you. So if you raise your hand, I won't ask you. Great. So, this is the right audience for this conversation. Patents protect function. Think of functional things. Trademarks protect the association between a name, or what we call marks, and the good. So for Ford, since we're talking about that, since we're here, you see the word Ford, you associate it with the car company. What I tell students and others is I'll draw on the board a big giant M. If that M is a big M, I'm going to call them arches, and they're yellow, what do you immediately think of? McDonald's, hamburgers. However, those of you who are from Michigan or follow football, if you see a block letter M and it is colored maize, do you think hamburgers? No, you think University of Michigan. So trademarks are very important to companies because they protect the association between that mark and the source of the mark. So you won't go into some place with the yellow arches and have someone throw a football in your face. Well, if you do, you might sue. But the point is that the association you have with that mark is for hamburgers, and they're going to protect that. You cannot just put a big giant M with arches in front of your store and then sell quarter pounders that are a quarter pound of sardines and cheese. And why am I telling you this? Because trademarks are very powerful. And before you get really attached to a name for your company or a name for your product, do a simple trademark search. In our office, we will teach you how to do that. You can do it online. Our website for the United States Patent and Trademark Office has many, many, many resources for you. A part of our website is designed just for innovators, not lawyers. I was talking to the lawyers this morning, and I was saying, when you go to our website, I know you go to our website and it says, what is a patent? And they don't want to know that. They immediately skip to another part. It's actually designed for you all. It is written in level. There are small videos and other things to tell you the things that you need to know as you go through innovation. So, the role of the system is to protect inventions, encourage inventions, promote commercialization and application, and accelerate commercialization. I talked about patents and trademarks. Trade secret. What is trade secret? I told you not everyone needs a patent. If you cannot reverse engineer your intellectual property, perhaps the way you want to go is trade secret. The United States recently just passed, in the past 2 or 3 weeks, a federal trade secret law. That provides, instead of the patchwork of trade secrets in different states within the United States, a United States-wide trade secret, just like you have for patent. Trade dress and design patents are for the way things look. It's for the overall shape, the ornamentation, the look and feel. Those are going to be very powerful for your industries. As innovations come up, you'll find that people tend to rush the system, and everyone's trying to get their own little niche. Perhaps patent may not be the right way for you to go, but maybe the look and feel of the way something is the correct way for you to go. How does that work? So you all know about the Apple versus Samsung case, where Samsung started with a flip phone, and the next year after the iPhone came out with something that looked very similar to the iPhone. They took Samsung to court for having something very similar. It wasn't about patents, your utility patents. It was about design patents. What they were saying is they copied the look and feel of it, and the court granted them a significant sum based on their design patents. So just because lots of you think, oh, software is not patentable anymore, first of all, that's not true. Secondly, there's other ways. Trade dress and design patents are another way. So back to patents. If you choose to go this path, some people will say, okay, well, it takes too long. I don't want to invest the time, the effort, any of that. Well, we have what's called a provisional application. The provisional application is optional. Why are provisional applications so popular? Because it allows you to put your stake in the ground, your flag in the ground, and say, this is what I am claiming as my territory. If I continue down this path and I'm granted the rights for it, then no one else can be in this area. If you're going to be in this area, you must pay me, or you have to must pay me, or I can make you stop. Even for those of you who are not wanting to go down this path, you should still be searching before you spend money to see if somebody else has already gone down the path that you're on. The amount of times where you see someone who spends time and effort working on something, only to, after they put all this time and effort in, to say, oh, now I'm going to go patent, and then do a patent search, and find out that somebody already owns that real estate. It's unfortunate and doesn't have to happen. One of the things that we do in the Midwest Regional Office is we allow for people to come in and do searches using the same equipment that our examiners use. So having the office, well, not to all of you close by, but here in Detroit close by, really provides a great resource. We have offices in Washington, D.C., Detroit, Denver, San Jose, and Dallas. The process to a patent, this is on the website. Again, as I said, most of our materials on our website are designed for people who may not know a lot. You see those a lot about IP. All those blue links means click there and we'll tell you how to do that. We make it as user-friendly as possible. We love flowcharts. Here are the offices, as I just mentioned, Detroit, Dallas, Denver, San Jose, and Alexandria. We bring services to the region. We come to all kinds of conferences, usually not the last one on the bill, though. We also have examiners there. So say you're working and you have a patent, you're working with someone, and you have questions, you want to have a conversation with your examiner, you can do that in our office. And we serve as hubs of outreach and education. If you were here yesterday, you may have heard that I mentioned to some people that we're having a autonomous vehicles and patents, autonomous vehicles and intellectual property roundtable in the near future. We've had lots of different events. We hit every part of the innovation ecosystem, from K through 12 to AARP. And not to forget that K through 12 to AARP and everyone in between. So one of the things I wanted to mention, actually going back to this slide, is that in our facilities, we have examiners, obviously, who are doing IP. You're in a disruptive industry. If you're going to choose to go down the patent route, we would love for you all to come in and explain to the examiners your technology. It makes it much easier later on when you're trying to get a patent because you're educating the examiners ahead of time instead of waiting until your patents are before them. As I mentioned, lots of electronic resources on our website. If you have additional questions, we have the Inventors Assistance Center. We have lots of quality initiatives. These are probably more than you're interested in right now, but some of the things that we're working on in our office is for those of you who are concerned about overly broad patents that are blocking your industry, we are working on increasing quality. We also have a new procedure called in the PTAB, which is Inter-Parties Re-Exam, and Inter-Parties Re-Exam and AIA trials and post-grant to cull out some of those overly broad patents. And here's another thing that's on our website that tells you each part of the process. And if you click on any of those links in the process, it will tell you how to take advantage of those things. One of which is the discount for small entities and micro entities. If you're considered a micro entity, you get a 75% reduction in fees. Small business, 50% reduction in fees. I'm going to skip this, because I went through one of the things that people often say is, you're not the small inventors we normally deal with, but small inventors will say, okay, so we get 50% reduction or 75% reduction in fees. What's really expensive is not the fees, it's the legal costs. Well, we have two programs where if you qualify, you can get free legal assistance. The Patent Pro Bono program, which is in all 50 states, and we also have the Legal Clinic program, which is in law schools throughout the United States. So that's all I have today. I have 33 seconds for questions, but it is the end of the day, and I know at the end of a 2-day session, I know your brains are burnt and you have flights to catch or cars to get into. Let me tell you, the highway is completely blocked, so use Waze. It'll help you get around it. But if there's a question, I encourage you to ask now or just wait a few minutes, and I will talk to you then.
Well, don't worry. I'm not going to rush you. Don't worry. There's no time pressure. I actually had one submitted, so we have a Q&A system.
Oh, yeah.
So does the PTO do anything to limit patent trolls, non-practicing entities who exist just to litigate others?
So we never say patent trolls. We say that there are people who abuse the patent system, and that's true. And how do we address that? I mentioned earlier we have two new procedures you can go through, which is post-grant and inter-parties re-exam, where you can take a patent that you think should not have been granted to get rid of that patent. That's a new procedure. It is very popular. That said, he didn't say who exists just to litigate others, just to litigate. If they have a good patent, it's no different from if any of you have a great idea and a great patent. You don't just get rid of the patent just because they are an entity that you don't like. It has to be something about the patent that's wrong. But on our website, we do have, again on our website, we have if you put in, I got sued, USPTO, you will come to a web page that gives you some facts, some procedures, so you know kind of how to deal with situations where someone is sending you a cease and desist letter. First of which is look up to see if the patent is actually valid and whether or not they own it, and other things like that. So we do all that we can to empower you as innovators, other than, short of giving you legal advice.
Great, thank you. And I mean, does anyone have any questions from the floor as well? I'm sure I can do some exercise. I'm sitting down all day. No? Thank you so much for your time. I really appreciate it, especially after you battled all of the traffic to get here. And I'm sure, is it easy for people to get in contact if they have any questions? Absolutely.
If you just put into a search engine, not necessarily Google, if you put in USPTO Detroit, or USPTO Midwest, either one of those, the website for my office will come up. So we're the United States Patent and Trademark Office for the Midwest. Any of you in the Midwest, if we're in your area, we're happy to come by and speak directly with you. And congratulations for making it all the way through. I know I never ever do, but so congratulations to you.
Thank you so much.